then submit for approval. Next of kin update process. Step 1. To update your next of kin, log into iConnect, then go to My Profile, then click on Update Next of Kin. Step 2. Input the details of the new next of kin, then submit for approval.
Good afternoon, good evening, members. We hope that you are faring on well from wherever you are joining the call from. Thank you very much for honoring the call this evening. My name is Anne. I'll be taking you through this webinar session that we have today. So a few house rules. On the chat session, you can you can tell us where you're joining us from this evening. And if you have a question, you can drop it at the Q&A session. Today, we are going to learn more about benevolent scheme. So if you have any question or you had sent your question earlier when we shared the invitation email or text message, we'll be able to tackle the same during the Q&A session. So just a brief history where the Safaricom Sacco has started or where the Sacco started the benevolent scheme. So benevolent scheme, we call it Hand of Comfort. This is a product that we offer to our members as a value addition. So this scheme was started in the year 2015, and the proposal was given to the Sacco by the Sacco members who by then were at the call center JCC. So in the year 2015, they gave us a proposal. So how this product came about, as we are all aware, those of us who probably are in Safaricom PLC, we are all aware how huge the number is at the call center. So you find that in a month, the staff members could be, contributing for a fellow colleague in terms of death contributions or the changa. We call them changa. So these members sat down and realized that they're doing a lot of changas. So they gave us a proposal on how the Sacco can help them with such kind of incidences where probably a member or a staff has lost a loved one, and they're looking for ways on how they can support their colleague. So they came up with a proposal, which later on the Sacco refined and came up with a benevolent scheme, which we call Hand of Comfort. So this is a product that is basically meant to cushion members or offer comfort to members in times of distress. And distress here, we mean death. A member has lost a loved one and you are not sure how to go about it, or you're not sure, or you don't even know where to start. So we encourage members to take up this product so that if anything happens, if you happen to lose a loved one, you don't take up a loan credit for the purposes of giving your loved one a good send-off. You simply go through the claim process, then the Sacco will be able to, support you through the claim. So that means you must subscribe to this product. separately from any other contributions you do in the circle. Then in case you lose a loved one, the circle will be able to come through for you. So we encourage you, if you are here and you have not subscribed to this product, we encourage you this evening to subscribe to it as we listen more into the, the legal details about benevolent scheme. Those who are eligible at, at the family level, how you can join in, and the benefits that are in it for you as a member. Thereafter, we'll be able again to go through the data, the benefits of you updating your data, your next of kin details or nominees details with the circle oftenly, so that in case of anything, your loved ones are always cushioned. So I hope you're telling us, or you're typing where you're joining the session from, as we just, we welcome our first guest speaker. I will introduce him. He's called Naftali Ngare, who is from our consultant, insurance consultant on this matter to do with benevolent scheme. That is Naftali Ngare. So Zamara is our insurance consultant on benevolent scheme. So when we started the benevolent scheme, it was yearly, it was fairly, or rather everything was being done by the circle, from onboarding to claim payments was being done by the circle. Then later on, we realized that we could not go on with the administration matters from onboarding to payments. Then we brought in Cusco, who helped us with the underwriting for some time. Then we moved it now to ABSA. ABSA with Zamara being our consultant. Naftali will be able to give you a brief history of Zamara and how Zamara is coming in on this matter. Thereafter, we'll have Mudibo, our legal officer, to take you through the importance of updating your next of kin details with the circle as often as you can. So thank you very much. For those who have joined us, I welcome Naftali Ngare to take it up.
All right. Thank you very much for the introduction. And good evening, members. It is a pleasure to be here just to have this interactive session with you to discuss some of the matters that relate to the benevolent scheme. This is quite a great initiative by the circle. And I believe most of you have witnessed the kind of help it has given to our loved ones, as well as our colleagues, and basically the whole Safaricom Circle fraternity. So my name is Naftali Ngare. I work for Zamara. We are insurance consultants, and we are just coming to advise the circle on the best practice and in terms of how to run with this benevolent scheme to ensure that there is seamless settlement of claims, as well as any issues that arise handled in the best way possible and as fairly as possible. So today I will also be taking you through some of the terms and conditions and how best to go about handling your any issues that you may have that relate to the scheme, as well as if you have a claim, in the unfortunate event that you have a claim, then you would be able to be sorted in the fastest or the shortest time possible. So I will share my screen so that I can take you through the presentation. All right, and you can kindly confirm that my presentation is projecting.
Yes, it is.
All right, just put this in presentation mode. Okay. Right. Confirm we are now on presentation mode so that I can go right into it.
It's loading. You can just go ahead. It's still loading. The presentation mode is still loading. Just go ahead with the presentation.
All right. Okay. So I will start by briefly introducing who Zamara is for those who may not have heard of or interacted with Zamara before. So Zamara is a consulting firm in terms of which works in consulting in the financial services space. So we majorly consult on pension administration, actuarial services, and insurance services. We have several arms within us that deal with financial wellness as well as product development and also consulting being our major and key role. So from Zamara, we are rooted here in Kenya, recently moved to Westlands near your offices. We are rooted here in Kenya, but we have offices across the East and Central Africa, whereby we have a Pan-African ambition and we intend to be in at least 10 countries in Africa before the close of this year. So at Zamara, we have three key values or three core values. We say we accept. Our core values are simplicity, empathy, and trust. And basically, we try to make or tailor make our services to become as simple as possible for you to enjoy them seamlessly, as well as be empathetic. You note that some of these areas that we handle come to assist you during the time of need. For example, on the Benevolent scheme, while it is a good way to support each other, nobody wants to be the one claiming from this particular scheme. So we do try as much as possible to earn your trust by making it very simple, seamless, as well as be empathetic and see the world through your eyes. Ensure that you're being treated by the insurer the way they would also want to be treated. So we have tried as much as possible to make the processes flow without any hiccups. And I'm sure that for those who have had any claims, you have been able to see that we have your issues have been resolved within record time. So today, I'll just look at and kindly confirm you're able now to see the presentation.
It's gone back. Put it on presentation mode.
Okay, I have.
It's okay now. Continue.
Right. So okay, I'll just move past these slides. All right, so without much further ado, I'll go right into our Benevolent scheme. The Benevolent scheme is basically a scheme established to help people who are within a formal group in times of need. So it can be any hardship. We can expand our Benevolent scheme not to only come in during times of grief. It can also assist members during other times, even times of happiness. You can say, for example, during a wedding, in case one of the members has had a new birth or anything like that. So it is not all times that benevolent schemes can be established to deal with matters relating to grief and bereavement. So basically what the current scheme that we have does is give you a cash benefit in the event of death of any of our loved ones. Basically, you would get a cash lump sum to assist you in defraying the funeral expenses. Also, it would also come into place to assist you during a period which basically you're tight on cash or things are not very good on your end. So a benevolent scheme is good. They have helped to remove the need for creating WhatsApp groups that would ordinarily be what people used to do there in the past in the event of bereavement. So the current benevolent scheme, usually there before, I think it was a pooling, kind of a pooling arrangement whereby members would contribute into a pot, and in case someone is bereaved, you would be paid a particular amount depending on your contribution. However, eventually, we recommend that the scheme is insured. With insurance, you're able to get a much higher amount and also attain sustainability of this particular scheme, because at times what would happen if the claims exceed the pool that members have put into the pot where we are taking from. So insurance comes in handy to resolve or to remove that risk and ensure that anyone who is affected would be benefiting from a certain amount depending on their level of contribution. So we have the current underwriter or the insurance company who is currently providing the insurance service, that is Absa Life Assurance. Absa Life Assurance is a subsidiary of Absa Bank, and they do provide life insurance services within Kenya and South Africa as well. So some may have heard of Absa Life, but I know people are more familiar with the mainstream insurance companies, for example, the likes of Jubilee, Britam, CIC. However, in terms of the dynamics of how this scheme operates, we did our market research and were able to identify Absa as the best suited in terms of providing service or providing this particular insurance. So usually the cover is an annual policy that we renew, that is renewable every 1st of October. And therefore, at that point is when members begin their contribution towards the scheme, and we contribute for 12 months or for 1 year, after which now, in case we have any people who want to come on board or any people who want to drop off, then are able to drop off at that point. So this, we'll go through what the scheme covers, but before we do that, we're going to do a definition of terms. Many are times where we've had members joining the scheme and they are not quite well aware on who it is that they can cover under this particular scheme. When you're filling that application form, you will be asked to nominate members of your family who you wish to cover. And it is important to understand who can be covered and who cannot be covered. Of course, the main benefit for you to qualify to join the scheme, you need to be a member of Safaricom Sacco, and you as the member will be the principal member within the cover. So the member of the Sacco, or the principal member, is the member of the Sacco who has filled an application form. We have the application form in the prescribed format by the Sacco, and once they are approved by the Sacco to join the scheme, then they automatically join the benevolent scheme. Now, the member is allowed to add their spouse, and a spouse means either a husband or wife who you joined through a matrimonial process as per the Marriage Act, or basically a legal spouse. So when you're joining, make sure that the spouse that you're adding to the cover, you're married legally. Normally, if you've not solemnized your marriage legally, you would be required to get either an affidavit from a magistrate that would again solemnize your marriage as a legal marriage. Note that this needs to be done before making any claim or before a claim occurs. We note that sometimes we have people who have claims before they have legalized their marriages. So it is always ideal to do this before a claim occurs, because then you would be able to validate your claim and of course make the payment quite quickly. For children, again, you're allowed to nominate a maximum of 4 children or to add 4 children to the cover. And a child basically is any individual who is below 18 years of age. and can either be related to the principal member by blood, whereby that is a biological parent, or is legally adopted by the principal member. So for children, I know we're in the African setting, whereby we have people who take up maybe their relatives' children, and they bring them up as their own. But for you to cover them in insurance, or to provide cover for them, you need to prove that there is insurable interest on that child. And therefore, you also need to acquire some legal documentation, either from a magistrate. Basically, the Children's Act of on Chapter 141 usually recognizes any child who has been recognized by a court of law as your child. You can have that child on the cover. So if you have a child that you have adopted, maybe from a family setting, and you have not given them, you have not taken up any legal papers for them, it would be important for you to get an affidavit or any legal documentation that shows that you're the one who is taking care of that child. And in case of a claim on this policy, then you will be able to get payment in a very seamless manner. Other children who have not been adopted in that manner, you would be asked for additional documentation just to show that that is actually a child who is under your care. Now, children who are above 18 years of age and are still in school usually can be added to the policy. However, at the point where we need to claim from this cover, then the child, you will need to provide proof that the child was still a school going child and was fully dependent on you as the parent. In terms of siblings, these are basically brothers and sisters. And how a sibling is recognized is whereby someone whom you have at least one common parent is who is the one who is recognized as your sibling. Basically, you can have one common parent by either birth, or it can be legal adoption. So again, if you have any of your siblings that have been your brother or sister by adoption, you need to maybe engage your parent just to get those legal papers to show that that is your sibling, and then that they will be recognized by law as dependents of your parent, and now can also be recognized under this policy as your brother or your sister. Any parent who is registered or who is recognized as a court of law to be taking care of a child, again, you can nominate that particular child as your sibling. In terms of parents, it can be either the mother or the father it can be either your mother or your father. And basically, you don't have to be related by blood. If you are legally adopted, or if you've been brought up by maybe your next of, maybe could be your uncle, could be your aunt, could be your grandparents, then you need to get some legal documentation to say that those are the people who have brought you up as your parents. So in absence of that, normally you would be requested to acquire one from a magistrate or a court of law to show that that is actually your legal parent or legal guardian. So these documents need to be acquired before the point of claim, rather than after a claim has happened. We find that most of the time after a claim has occurred is when we get such information that this was this parent is just my adopted parent, but is not my biological parent. So in such scenarios, you would want to have some legal documentation to demonstrate that that is your legal guardian. Parents-in-law is another area of that we've seen a lot of questions being asked. Parent-in-law is basically the mother of or father of your declared spouse. So you cannot have a parent-in-law and you do not have a spouse, you have not declared a spouse. So for those who's, in case somebody has a spouse who has already passed on, or their spouse is not on the cover, you need to have provide some proof that that person is actually your parent-in-law. It could be a marriage certificate, or it could be a legal affidavit showing that those parents are actually your parents-in-law. Again, acquire this before a claim happens, not after there has been an incident. Now, with that in mind, we would be able to enroll particular members of our family. For the principal members, the minimum entry age for you to enroll is 18 years, and the maximum entry age is 70 years. So you are able to join the circle at any point between 18 and 70, and we'll be able to cover you. However, after the age of 70, we will not be able to provide cover for you in this case. So after you join the scheme, you will be retained on cover until you exit the scheme. There is no maximum cover age for principal members. For the spouse as well, the maximum entry age is 70 years. And of course, there is no maximum cover age for the spouses as well. For children, if you have a child, ensure that you give this information to the customer service team for your child to be enrolled onto the cover after 2 weeks. So after 2 weeks, the child can be put on the policy, and then they will be held on cover up to the age of 25 years. So any child who is aged above 21 years, at the point of claiming, you will be asked for proof that that child is still in school and is fully dependent on you before a claim is paid. So note that we can only know that you have a new member to your family if you share that information with us. If you do not share the information with the customer service team, then there will be a problem in case your child has not been enrolled to cover. For siblings, you're allowed to enroll your siblings after 1 month from birth and up to the maximum entry age of 70 years. However, the cover for siblings is limited to 70 years. Once a sibling hits the age of 71 years, then they are dropped from this policy. Parents and parents-in-law, you can enroll parents from the age of 30 years up to a maximum entry age of 84 years. So at the time of joining the scheme, it is important to make sure that a parent is between these ages, between 30 and 84 years. If a parent has exceeded 84 years, then they cannot be enrolled to the scheme. However, if you enrolled your parent before the age of 84, they will be retained on cover up to the point of death. We do not have a maximum cover age for parents and parents-in-law. All right, so we have various tiers on the scheme, and we have the minimum benefit that is the lowest level of cover. That is where the member is covered for 100,000, and the spouse is covered for a similar amount of 100,000. And children, you can declare up to 4 children will be covered for 50,000 on that level. Siblings are covered for 20,000. Parents and parents-in-law 50,000. The second level, we have the member being covered at 200,000. That is the member and the spouse. The children are covered for 80,000. Siblings are covered for 40,000. Parents and parents-in-law covered for 80,000. The third tier, we have 300,000 for the spouse and the member. And then we have children covered for 140,000. Siblings are covered for 80,000, and parents-in-law at 140,000. The highest level of cover is 400,000 for the member and their spouse. Children covered at 150,000. Siblings, the maximum cover is 80,000, and for parents and parents-in-law, it's at 150,000. Basically, you can add all these members to the cover. You can add a maximum of 2 parents and 2 parents-in-law, 4 children, 1 legal spouse, and a maximum of 4 siblings. However, as much as you have added all these people onto the cover, the maximum number of claims that can be paid for one family in 1 year of cover is 5 claims. So if you make any claims, you can only make up to 5 claims within your family or within your declared members. And it doesn't matter which claim came first. We'll pay the first 5 claims, and then you would have to wait for the next cover period for you to be put on cover again. Again, we have siblings within the circle who have covered the same parent. So we have, for example, maybe I have a brother or a sister who is also a member of the circle, and we've both covered our mother. So we can only have a maximum of 3 siblings covering the same parents. The maximum amount also available payable per life is 750,000 for any life. So note that if we have, for example, 3 siblings who have taken cover for the same parent, we will only pay 3 siblings. That is, if it was for the maximum limit, 150,000. Say that same person has a brother or a sister who is also a member of the circle. We will pay up to a maximum of 750,000. So in case the amount remaining up to the limit of 750,000 is lesser than what you have covered that person for, then you will get the difference, or what is remaining for you to hit the cover limit of 750,000. So the decision on who joined first, of course, will lie on the insurer. Of course, the first person to make the claim will get priority, and so it is on first come first served basis. And when their siblings joined on the same date, then the proportionate ratio of benefits shall be applied. So if we all joined on the same date and we have claimed for the same life and the benefit is more than 750,000, then we shall apply proportionate ratio for the benefit. This tells you that within the family, you need to align and know who has actually covered, especially parents, because you may find that one parent has been covered by more than 5 people within the circle, because we as siblings are on the circle, our uncles and our cousins are also on the circle, and they have maybe covered the same life. So I trust that is noted, and within families as you join, make sure that you know who has covered a particular life of common interest within that particular family. This policy also has some waiting periods. Once you join, or once you fill the form today and you join the circle, you cannot make a claim on the principal member or the spouse or the children within the first month. So unless the death is accidental, then claims relating to, or any deaths relating to illness are not payable within the first month of cover. For parents and parents-in-law, you cannot make a claim unless the death is accidental within the first 3 months of cover, and that also applies for siblings, that is brothers and sisters. Basically, this is to reduce or to alleviate the risk of selection, whereby we have people who invest in these covers at the point at which they maybe realize that something is about to happen, and now they enroll their loved ones on cover to benefit from the policy. In that way, then the policy would not be sustainable, being that we are creating a pool of funds for the benefit of all members. And when some people join at the point when they claim, or just when they need to claim, then we would end up paying a lot more for us to make this scheme sustainable. Right. Now, having understood the benefits, we can now look at what we need to do when we have a claim. For you, the member, it's very simple. You need to first inform the customer service team of the incident as soon as reasonably possible. Do not wait for a very long period of time. It is also important to notify your next of kin that you have such a policy in place in the event of anything happening to you. So as soon as reasonably possible, inform the customer service team, who will also inform the insurer and the Zamara, and then the insurer will advise the customer service team on any relevant documents that relate to that particular claim. So the customer service team will advise you on any additional documentation, and will also tell you why additional documentation is required if it is over and above standard documents that we request. All right, so the documents that you need to submit while you're notifying the claim. One, we have a completed funeral claim form. which is available. Once you report a claim, the form will be provided to you. It is available to all members. You fill the form, and as you submit the form, you will attach a copy of a burial permit that is stamped by the issuing office. It could be the chief, it could be the police, it could be a hospital, but whichever authority has issued the permit is required to stamp it. Where a burial permit is not stamped, note that you will be requested just to have it stamped for your claim to be validated. I will also require your ID or passport. Your ID is required to validate your names with the registrar, and then we also require a copy of the deceased person's ID or passport. So if it's a child, of course, the birth certificate will suffice, and where this is not available, one will be requested for maybe any legal documents that show that that child was under your care at the point of death. For siblings, brothers and sisters, we require a birth certificate at the point of claim. Basically, this, as I said earlier, a sibling is somebody who you share either one parent, at least one parent. So once you provide that, then the insurer is able to verify that this is actually your brother or your sister. And sometimes, depending on the type of claim or where there has been reason to, other documentation may be requested for. And mostly this is usually an affidavit in case the documents provided, for example, have details that are not matching with what is on either your ID, your birth certificate, or even on the burial permit. So these documents will be submitted to the customer service team, and once they have received it, then they will forward to the relevant parties, and you will receive your payment within the shortest time possible. Right. Some of the gaps that we have majorly experienced is on declaration, whereby members have either changed their status. For example, somebody has gotten married, and now they have a spouse and they have parents-in-law, but they forget to notify the SACCO to add the spouse and the parents-in-law on cover. And then at the point of claim, we find that the parents-in-law or the spouse is not on cover, and now we are forced to ask for additional documentation to show that this is actually your dependent. So anytime you have a new member of the family, please make sure that you do notify the SACCO, and then this member will be added to cover. Legal identification documents have also been quite a challenge. One, when you're declaring when you're providing the names, for example, of your parents, you should make sure that the names match the name, the ID or the passport of that particular parent. Because if you provide the names of your parent and we put them on cover, then at the point of claim, we find that the names you provided us are not matching the ones on the ID. Then of course, that will automatically require some additional documentation just to show that that is actually one and the same person. For those who have adopted children, or for those who are taking care of children who are not children to them by birth, then you need to obtain the necessary legal or guardianship documents. So do not wait until a claim has happened for you to get an affidavit. Take it now or as soon as possible. And then at the point of claim, you will have a very seamless process while you're making these claims. So I do urge all members to make sure that if you have changed status, please update your details, update your children, update your parents-in-law, so that, and if you have changed your spouse, please also ensure that you have changed that. Note that you're only allowed to change your spouse at the date of renewal. You cannot change your spouse mid-cover. You can only change your spouse at the beginning of the next cover period, which is 1st of October. So in between, once you put in a spouse, you will not be able to change them in between. So we really do urge you, especially on this legal documentation, to make the process seamless. make sure that you have obtained at least any necessary legal documents that will allow you to be paid any benefits that are due to you. So I will stop my presentation at that and give it back to Susan, and Anne, just to take us to the next part of the presentation.
Thank you, Naftali, for such a beautiful, informative session. Our members are now enlightened, and I believe that members, you are now enlightened. They say information is power. And after this, we are going to introduce our legal counsel, Mudibo, to take us through another session for just a few minutes before we engage the Q&A. We engage into Q&A. So a few points that has come out clearly. Benevolent scheme is basically meant to cushion members and also to, help us in that time of distress when we don't know where to start from. So we have been clearly taken through who is eligible and the eligibility. Members, I hope you've taken note of that, who is eligible and eligibility, which mostly covers the age at the point of entry, the requirements of joining this scheme, and also the definitions that most of the times we struggle with, like who is a child, who is a sibling, who is a parent-in-law. So today you've been clearly explained to who is a parent-in-law or who is a child. In case you're bringing your child on board, is your child by birth or by adoption? You need to prove that. And we have also been taken through the claim documentations that you need in case you lose a loved one and you're claiming. Then we are also, we've also been taken through the legal documentation, which our legal counsel will elaborate more. So I take this opportunity to introduce Mudibo to take us through the next session briefly before we go to Q&A. So Mudibo, we have about 10 minutes left. So kindly take us through very fast so that we can allow members to continue with their other businesses. Thank you.
Yes, hello. Vivian, can you see my screen? You're muted, Anne Vivian. Okay, it's okay, fine. Let me begin. Okay, thank you. Members, my name is Stephen Mudibo, as introduced by Anne Vivian. I'm actually the legal officer for the SACCO. So today I'll take you through a critical area of this presentation, let me just put into presentation mode, where our topic is understanding the difference between next of kin and nominee and the importance of updating members' data. So without further ado, I'll go straight into the key agendas. So basically the agenda, as I said, is to understand the key difference between next of kin and nominee and how they impact on the SACCO members, and also to understand the importance of updating records, member records, telephone contacts, nominees, and next of kin. So just by introduction, there are two types of nominees. Just even before I go to that, usually what happens out here, there's a huge confusion even amongst top tier SACCOs. Even as of now, if you go to the website of many top tier SACCOs and mid-level SACCOs, you'd find that many SACCOs introduce the nominee appointments as if they are the same as next of kin appointments. So this is even something that some of the judicial officers struggle whenever they are writing their judgments. You find that they mention next of kin to mean a nominee. These two concepts should not be confused, and that's why it's important to mention this. And I will go categorically into the two types of nominees as their impact on SACCOs. The first type of nominee is the nominee by a member, that is for the benefit of getting proceeds of a SACCO. And this nominee is in exception of the benevolent nominee. The second nominee is nominee by a member to a benevolent fund. So I'll start by SACCO nominee. So who is a SACCO nominee? A SACCO nominee, as I can read it verbatim, is any person who is selected by the deceased SACCO member during their lifetime to receive their SACCO benefits proceeds upon the death of the SACCO member. So, and I will come to this concept later, whereby I say a nominee need not necessarily be a next of kin. Because if I explain further the definition of next of kin, you realize that a next of kin doesn't necessarily have to be a nominee. I hope we are clear up to there. If you can get this concept, first of all, of a SACCO nominee, then as we move forward to the next of kin, it will all make sense later. So, appointment of nominees. The act, that is the Corporate Societies Act under Section 32, brings out the definition, appointment of nominees. How can nominees be appointed? So, a nominee can be appointed, first of all, for the appointments of nominees to happen, the rules, that is the Corporate Societies rules under Section 32, provides that every member of a society may appoint his nominee or nominees for the purposes of Section 39 of the Act, now the Societies Act, which now states that under Section 39, that this is the part which states the transfer of shares of deceased member. So to move on, what the member needs to, as an appointment of a nominee, the member, that is the member nominating the nominee, needs to have more than one share if that member intends to appoint multiple number of nominees. This means that a member of the SACCO can appoint several nominees as beneficiaries of the process of his SACCO. So what the Act is saying, if you need to appoint if you need to appoint a number of nominees, you need to have more than one share in the SACCO. The second point is the member needs to specify the number of shares to be transferred to each of these nominees. So what usually happens is, if you appoint, let's say, for example, 3 nominees, and we know that the number of shares is, let's say, depending on the number of shares you have, the total number of shares, you can specify that maybe say this member gets 25% of the shares, the second person gets 55%, and the other member gets the remainder. The nominee gets the remainder. And then, if one has to appoint a nominee, the formal requirements of the law is that this nominee must be appointed, must be nominated in writing, not just by verbal, and you maybe say you walk into the SACCO and you say, I want to nominate this person. It can never happen that way. It has to be, these are the formal requirements of the Act and the regulations. That is, you must be in writing and signed by the member in the presence of 2 witnesses in the prescribed form. So the Act has given a prescribed form, but we have taken time to adopt it. And so in every nomination, there needs to be at least 2 witnesses. This is to avoid any doubts in future in case somebody lays a claim, another person lays a claim that, oh, these formalities are not followed or whatsoever. So once the member nominates a nominee, the society needs to acknowledge that this nominee has been appointed. It can be through the authorized, authorities of the SACCO, saying that in the form that maybe has been filled, saying that we acknowledge this nomination, something like that, to just authorize the same. And then I'll go to, this applies to nominees when you're nominating a minor. So there's the rules say the money paid to a nominee who is a minor, a receipt given either by the minor or her guardian shall be sufficient discharge to the society. So if you, the SACCO gives, if the SACCO gives and appoints, let's say if the member nominates somebody, and when it comes to issuance of the proceeds, and if it's given to the minor, it will be considered that without even necessarily giving the guardian, it will be considered that the SACCO sufficiently discharged its obligation to award this proceed to the member, regardless whether the member is a minor. So it's trying to safeguard this interest of the nominee. And so the rules also say that where there is no appointment, where is no appointed nominee, the society may pay the money due to the deceased member to the personal representatives. So personal representatives, by legal definition, these are people who are legally appointed by a court to represent the estate of a deceased person. So the case law that supports there's this confusion. Before I come to that, there's this confusion that people always think that for SACCO, any proceeds of a SACCO need to be handled through a succession dispute. That is not true. Where the Act, as the courts have over time ruled that where there is a statute which gives authority for the nomination of for the member to nominate a nominee, those proceeds of the SACCO will not, or whatever scheme, and as it applies to us now, the SACCO Societies Act, the Act says that whatever scheme that has, whatever nomination that happens, or the proceeds of the SACCO, those proceeds cannot and will not form part of the succession petition. So the courts have also confirmed this, and here is a case law by Justice Musyoka, that is in 2015, where in the case of in re-estate of Caroline Acheng Waga, and I'll just read it out verbatim, it is the law that the funds, the subject of a nomination, do not form part of the nominator's estate, and therefore such funds cannot pass under the will of the deceased or vest in this personal representative. Such funds are not subject to the succession process and should be dealt with in accordance with the law governing the nomination. Nominations are statutory in the sense of them being specifically provided for by a particular statute. So the court is actually saying what I've been saying. And even if somebody comes, let's say a relative of a member comes and says, oh, but you know what? I've gone to the succession court. I've gotten this grant, confirmation of grant, and I am I'm the bona fide beneficiary of the proceeds of my deceased husband or wife or whatsoever. This case says, Justice Musyoka said, is that it is whatever confirmation of grant you come with is worthless, because in itself, the court does not have the jurisdiction. Jurisdiction to me does not have the capacity to determine cases involving the proceeds of a deceased member in a SACCO. So the court doesn't even have that authority. If the court doesn't have that authority, it cannot even make a determination on how these proceeds can be given. Okay, there are so many cases to this, but this is the main case that has created traction in the industry. So also, when it comes to the cancellation and replacement of SACCO nominees, Section 32(10) of the rules state that for nomination of a new member to be that the nomination of a new member still has to be in writing and to comply with the normal standards of nomination. This is to mean that, as I stated previously, all the requirements that are needed, that it be in writing, that be to witnesses, and all that need to be complied with and submitted to the SACCO. The third thing, okay, now I'm coming to the benevolent nominee. I had spoken about the SACCO membership nominee of the nominee to get the proceeds, that being the shares, the dividends in the SACCO. But now we have the benevolent nominee, which is now the relevant part of this discussion, because the previous presenter had spoken about the benevolent. So the benevolent fund or scheme, we previously mentioned, is a scheme is to established to assist members in case of death of their spouse. It's like a welfare scheme to cushion members from these sorts of mishaps in their life, bereavements, and all that. And it's usually given to close family members. So a benevolent nominee is an appointee by the SACCO member to who, when the nominee demises, the SACCO member will benefit from the funds. And for a benevolent nominee, this is the distinction now between the benevolent nominee and nominee as a member, nominee by a member for the benefit of getting the proceeds and shares in the SACCO. So the difference being that for a benevolent nominee or beneficiary, the nominating member need not be deceased. So, for example, I can take my example. Let's say I'm a member. Of course, I'm a member of the SACCO, and then I decide to nominate one of my relatives. So unlike the nominee where one has to, the member nominee for the process of the shares of the SACCO, where one has to, the member has to die for now the proceeds to be distributed to the nominees. This one, the death only, the member by himself, now me, I don't have to die. The benefit, how it applies is that the people who have nominated, if one of them dies, that's when I'll be able to get as a support through myself to cushion me through all these challenges that I'm facing. Then now I come to remember I said the first thing was defining nominee, and I broke it down into two: for the member, a nominee for purposes of proceeds of the SACCO, and also a benevolent nominee. Now I'm coming to next of kin. This is now where I say previously I'll expound a bit further. So a next of kin, it refers to the closest living blood relatives of a person. So it can be, closely living blood relative, mom, aunt, brother, sister, such things. So, and the next of kin need not be a nominee, because as we said previously in our slides, a nominee is any person who has been appointed by the member of a circle. So it mustn't be a close blood relative. So where the next of kin isn't a nominee, they cannot benefit from the circle proceeds to the deceased member. Yeah, it makes sense, because if you're not nominated, no matter even if you're a next of kin, you will not benefit. Okay. The next, now I'll move quickly to. I'd spoken about these things previously in my explanation. Now I'll move quickly to, because I have limited timelines, importance of updating a member's data. One of the importance of updating a member's data is to enable the member to update the circle on developments in their life. For example, you might find some people actually nominate people in the membership form, and because of the normal compliance requirements, at that time you might have just given down a name without further thought about it. So in case there are developments in your life, let's say one becomes married, later on you might find more important people to benefit from your proceeds of the circle. So that's why it's important to give us these updates. For example, saying you're now married and you now want to nominate your wife. So or if any member of that you nominated died, it is important to also update that record so that we can actually advise you to now nominate a new person. Also, if you have a child, you might opt to nominate them to be amongst the nominees. As I said, you can have a multiple number of nominees. You can, let's say, if you had nominated the first one, you can go ahead and add your child and any other children that come along, your spouses, your friend, as it applies, and based on and you give them you identify how much of the proceeds they will be able to benefit from the circle. Let's say if it's 20%, 30%. The other benefit of updating members' data, and this comes across nomination or next of kin, is to give the circle accurate records to be relied on during an emergency. So mostly during, let's say, for example, and this comes across in next of kin, when there's an emergency and maybe the circle is trying to identify who it can reach out to, your next of kin will be the person who will likely be of much help to us, because we believe they are closely related to you. And so that's why it's important to update those records, and generally to also enable ease of communication. So if you're updating us with any information, your email address, your number, and all that, it will be very important, because it will enable us to reach you quickly, as opposed to trying to figure out where are you now, what has happened in your life, and all that. So I don't know if, that was the last slide. Okay. We also, just to put it very clear, since we are regulated by the Office of the Director of Public Prosecution, as a circle, we guarantee that all information that we obtain from you regarding your data will be kept confidentially. And this is a requirement as I've said, by the Data Protection Commissioner's Office. And we guarantee you that your data will be kept safe, so that you need not have any worries in case you update your data. So thank you, and I can give the mic back to Anne Vivian and Susan, and I welcome any questions that members have.
Thank you, Mudibo, for that informative session. So members, we are now going to the Q&A session. So I'll just read out a few questions. We still have Naftali and Mudibo who will be able to answer questions. So I'll go through the the questions, then read it out to you, Mudibo or Naftali, then you'll be able to answer it. So,
sorry, Anne Vivian.
Yes.
Can I just mention something before I can begin the question and answer?
Go
ahead. Just to update you members, as I said previously, the idea of nominees and next of kins has been something that has been confused largely in the industry. And so you find most of the time, as even in the circle, as it applies in a circle and other circles, most people will put the next of kin, thinking that they are with the intent of having them act as nominees. So since these forms we've largely been using them, what we have decided to do is to honor all these next of kin forms, so to act as nominee forms, so that we avoid, having, members coming and flocking our office to update this. So we'll honor that. And for the new upcoming members, we'll undertake to have the forms updated so that we can capture the right details. Thank you.
Thank you, Mudibo. So also to reiterate on that, members, we recently shared communications on next of kin update or data update on Benevolent. So kindly update your data. And if you received an email that you are missing one or two documents, kindly we also urge you to respond to that email by providing the documents that we need from you. And as earlier said by Naftali, we continue to urge you to update your next of kin oftenly as you get new family members. That is on the membership. So my first question goes to Naftali. On the definition of terms, under sibling, what does one of two or more mean? So I hope you note it down. I'll read at least two or three, then I can give you the mic. On the definition of terms, under sibling, what does one of two or more mean? That goes to Naftali. Number two, are you to cover step parents or guardian? That also goes to Naftali. In the event a sibling is married and they get a new ID with the name of their spouse as their third name, what documents shall be required as proof that you are indeed siblings when making a claim? So those three, over to you, Naftali.
All right. Thank you, Anne, for those questions. I think the area of one of two or more basically goes to advise that we do accept more than one sibling to be nominated to the policy. That's why we are saying one of two or more, but the maximum is 4. So we allow you to nominate up to a maximum of 4 siblings to this policy. That the claim we will not pay more than 5 claims for the whole family, as much as you have more than 5 members of your family on cover. All right. On to the second question, the issue on the step parents or guardians. You are allowed to have a step parent or a guardian on cover. The key issue here to note is that you need to have legal documentation that confirms that this is your guardian. For a step parent, so long as you have either a birth certificate that you have one particular parent, if they are married legally, then so long as they are married legally, then the step parent will be recognized as your parent. The only issue that we always have is where, especially for adopted children, where people do not have any legal documents that can confirm that truly this is actually a parent. I would like to urge members to note that the insurer or on our end, we have no way of knowing who is your parent. Even if you go meet a friend out there and you decide to nominate them as your parent, then you can do that. However, for the insurance company to determine who your parent is, the only way for them to do this is by legal documentation. So you either get an affidavit to show that that is actually your parent, or you can, for those that are step parents, so long as they're legally married, then you're able to provide legal documentation, for example, either a marriage certificate or something to show that they're actually married for you to nominate them. Right. The third question, I didn't quite get it, Anne. Maybe you can just bring it up again.
So the third question was, In the event a sibling is married and they get a new ID with the name of their spouse as their third name, what document shall be required as proof that you are indeed siblings when making a claim?
All right. Where somebody has changed their name or they have added a name, then basically for siblings, the birth certificates are the most important document. And if birth certificates are not available, remember your birth certificate indicates who your parent is, and as well as even a marriage certificate indicates who your parent is. So if you share one common parent, then automatically, then that is proof enough that you are actually siblings. So at the point that you change your name, we will not ask you to maybe tell us that the sibling has changed the name at that point, but it is important for you to notify us. However, at the point of claim and the names are not, maybe the names are not matching what you had declared, then you'll be asked to provide such documents. You can either provide a marriage certificate or the birth certificate that will show that truly you do share one or more parents with that person.
Okay, we are still on Naftali.
All right.
And another question, hi, why do we include siblings who are over 18 years, yet the children are only allowed up to 18 years? Also, if I have more than 4 children and I'm forced to exclude the ones above 4, yet I'm allowed to include my siblings who are over 18 years. Isn't this a bit skewed against my immediate family? So just briefly, you can answer that.
Yes, a very good question that is. Now, you will note that insurance is limited to legal provisions or our laws of Kenya, and the coverage for children is heavily regulated under the Insurance Act. So we are limited to covering children up to 25 years. However, there is no law that is there limiting the coverage for siblings. There is actually no law that defines the coverage for siblings. So that's why we are able to provide cover for siblings up to a higher age limit compared to what we can provide for children, which is limited to 25 years under the Act. In fact, for children who are under the age of 10 years, we cannot pay more than 100,000, or you cannot cover them for more than 100,000 shillings.
Okay, thank you, Naftali. Try to be a little bit faster and brief. More questions are coming in, and I'm seeing that time is almost not on our side. So, but members, today is your day. We shall be able to tackle most of the questions. So just stay put. Don't move from this webinar. So the next one is, in the event that a demise has occurred and some of my siblings are also in the scheme, would we all be eligible for support under Benevolent? So another one, consider allowing children over 18 years or 25 years and those who have more than 4 children to have a choice of including the extra child at the expense of a sibling. You can answer those two, Naftali.
All right. In the event that a demise has occurred, you cannot replace a child with a sibling or a sibling with a child or any other member of the family with another, because of the limitations that we have, again, legally. Again, it is also to limit the risk of selection, whereby people only declare people would declare where they intend to have a claim or where they think that they might have a claim. So in terms of allowing children above 25 years, that is limited by law. We will not be able to do that. However, we can make a provision for more than 4 children at an extra cost for members. I trust this, if members are welcome to that, we can make a provision for that, and they will be able to add an extra child or even an extra spouse for those that are legally married.
Great. These age restrictions around adult children and older siblings is very unfair. Is this to mean that, God forbid, a member loses an adult child, we leave them to their own devices? And are we to ask our older siblings to die before 70 and our parents before 84? I think that's a comment. You have already answered that. Unfortunately, it's a very painful, or it's a painful comment.
Let me just say something in addition to that question. For parents, you only need to enroll them to the policy before the age of 84, then they will be covered for the rest of their lives. We don't have a cover limit. You can only not enroll your parents when they are above 84. But for siblings, the limitation of 70 is based on the principle of insurable interest, whereby a person who is, say, for example, 30 years is not dependent on you per se, and they can take cover for themselves and be covered even above 70. So encourage them to be members of the circle, and they will be able to be covered without an age limit.
Okay, I appreciate for the seminar. However, it should have come earlier to enlighten members to make informed decisions before the date to continue or drop lapses today. So I think I can answer this. We earlier said that this scheme runs on a yearly basis. It is renewable yearly. So we are about to start the next. We are about to renew Benevolent scheme. So if you are here, we are renewing Benevolent scheme starting 1st of October. So just get ready with all the documents. Then it will go all the way to September 30th. Yeah. So another question. In case of death happening to the principal member and next of kin, where is the claim paid? In case of death happening to the principal member and next of kin, where is the claim paid? And if other members were not aware, does the circle ever analyze unclaimed benefits? That is number one for you, Naftali. Number two, what criteria is used to limit my 5th child? Number three, if a sibling passes on and one is unable to get their birth certificates, are there any other valid documents that can be used for validation?
All right.
Over to you, Naftali.
On the first question, I may not be the best person to respond to that, but I think in terms of a nomination of next of kin, where a member has passed on, the next of kin that you had nominated is the one who receives any benefits. And it is the duty of the member to inform the next of kin that they do have such a cover in place in the event of their demise that they need to actually claim. I may not be able to respond on whether the circle has analyzed any unclaimed benefits. I think, Anne, you're better placed to respond to that. In terms of the criterion used to limit the 5th child, basically the premium that you pay is for up to 4 children. We'll make a provision for you to add a 5th child, but that will come at an extra expense to you, the member. If a sibling passes on and one is not able to get a birth certificate, you will need to swear an affidavit before a magistrate, not before an advocate, and then we'll be able to process the payment.
Okay, so Mudibo, please answer us on the unclaimed benefits. Where a member loses, where a member passes on, the next of kin also passes on, and the other family members or the other kin, next of kin members were not aware that he or she had such a scheme in the circle. So
Yes.
as you wait for Mudibo, okay,
Yeah,
go
yeah,
ahead.
yeah. So in that regard, as you said, a member passes on, but also the close family members, you said passed on.
The next of kin passes on.
Or
Of the
next of kin
beneficiary.
or
The
beneficiary passes on.
yes, passes on, yeah.
Okay. Now, how the law treats this is we have the unclaimed financial assets, but as regards SACCOs and how these proceeds are treated, the law provides that that the same be put through a public trustee. This public trustee will be able to advise on maybe there are timelines. Usually by law, there are timelines of any other claim, even if the next scheme have come about. There are timelines unto which this any other person who lays a claim to the same to present themselves. If they do not present themselves within the required timelines, then the law will act as if the same reverts back to the state. Is that clear for all?
Yes.
Okay, very
Yes.
clear. Another question, what is the legal recourse in instances of overly delayed payouts to mean delayed over the 1 to 3 month period, as earlier stated? Someone had expressed it has been 2 years since they made the claim. So we have a period of 6 months that if you are to make a claim, you only have 6 months to do it, because the cover is running for 1 year, then you renew. So within 6 months, you should have claimed. If I separated with my spouse and married anew, can I register my current spouse with the children I had from the previous marriage? Okay, Naftali, you'll take up that. Then
Yes. For spouses, you can only have one spouse in one cover period. So the spouse that you enroll on 1st of October will be the spouse that you cover up to 30th of September. And after that, you can change the spouse. For the children, they are allowed to remain on cover with the even if you change your spouse, so long as they're your children.
Okay, someone wants to know what's the relationship between Zamara and SACCO? I also didn't understand the topic about nominated beneficiary. Okay, so the relationship between Zamara and SACCO, Zamara is our insurance consultant on matters to do with benevolent scheme. And I also didn't understand the topic about nominated beneficiary. So Mudibo, you'll briefly explain nominated beneficiary.
Yes. So just and Vivian, just to be very clear, a nominee is a beneficiary in the context of first, when I said the nominee through a member for the benefit of getting the proceeds of the SACCO, that being shares, dividends. And also there's a second nominee for the purposes of the benevolent scheme. So those are two distinct nominations. So for purposes of just getting clarity, a next of kin, as I said previously, need not be a nominee, because a next of kin, as I said, is somebody who just is a person who has been appointed by a member to be a close contact in case of incidences where the SACCO needs to get clarity in terms of the whereabouts of the member, or there's an emergency that happened. This is the closest person whom the SACCO can reach out to for purposes of contact. But this next of kin, as I've said before, isn't a beneficiary, but they can still isn't a beneficiary stroke nominee. They can still be a beneficiary stroke nominee if they have been nominated by the member through the member nominee and the benevolent nominee. So I hope that is clear, and I hope I'm not confusing you more. Okay. It is a very dicey issue that, as I can say, over time, even many circles are struggling to understand the nominee and the next of kin. So there's that confusion that comes about when when I'm trying to explain. But if you can just get this simple concept, know that a nominee and a next of kin are different, and the person who benefits from the proceeds of a member is the nominee. And once you know that, then it's very clear.
Okay, Mudibo, just still on that, another question member is really insisting. Please confirm for current members, the next of kin is ideally the nominee. Also, please confirm this. The presenter mentioned next of kin is not necessarily the nominee. I think this is touching now on the membership. As for Benevolent, on that form, it is clearly indicated nominee and not next of kin. So, Mudibo, clearly
I can
confirm.
expound on that. Yes, as I said previously, next of kin is not a nominee. So what has been happening, and as I said, even through the industry, many people within the SACCO industry, even top tier, even as I say, some judicial officers, always perceive that a nominee is a next of kin. They are not the same. So even while we were drafting our forms, because of what was applicable then in the industry, we only had the next of kin, and it was perceived that the next of kin will act as a nominee. So what I said now, since this is a common anomaly across the industry, we will undertake to honor this next of kin's appointed to act as nominees, because that was the intent of the members whenever they were appointing these people as next of kin. They wanted them to act as nominees. So we'll honor that, but moving forward, any new appointments for nomination will have a form that is clearly updated saying the nominee and also saying the next of kin, so that all these are captured very well.
Okay. The last one to you, Naftali, then we can call it a day. If you have a sibling, members taking the scheme and a claim for a patent arises, these are parent, a claim for a parent arises, are the siblings paid separately or do they share a single benefit? So quickly on that, Naftali, then we can close it.
All right, a maximum of 3 siblings can cover one parent. Each claim will be treated separately and each sibling will be paid separately. The limit of the benefit is 750,000. So
Okay.
I think if you're 3 siblings, the maximum amount for parents is 150, so that is sufficient to pay the 3 siblings to their full amount.
Okay, thank you, members, for joining the call this afternoon. We have come to the end of our member education or presentation on benevolent scheme and updates of next of kin details. So we will share this webinar through text message and email and through your emails. And up to this point, we are urging you that please confirm or respond to the emails that we shared with you on your next of kin updates, which you can also do online. And if you got an email asking you to provide certain documents, kindly do so. It's very important that if it's a membership form, please just fill it up and indicate the details clearly, then share it with us. And thank you. Thank you once again for honoring the call. Until next time, have a good evening.
mwende nyumbani ama?